File number 22-93215FH for sentencing. I have received a letter from Sable Valley CMH and from Go Team Services on behalf of the defendant that I have reviewed. And Mr. Piper, have you had a chance to review the pre-sentence report with your client?
I have, Your Honor.
Any additions or corrections to that report?
It is factually accurate, Your Honor. I have some comments to make during elocution, but nothing that needs to be added to this.
Okay, and the advisory guidelines were scored at 0 to 17. Any scoring challenges or no?
No, Your Honor.
Mr. Radsabon, any additions, corrections, or scoring challenges?
No additions or corrections, Judge, and I believe it's scored appropriately.
All right, Mr. Piper, go ahead.
Judge, this represents Mr. Luttrell's first felony conviction. I went over the report with him. He understands what the recommendation is and the reasons for the recommendation. He would, however, like the court to consider whether we're placing him on probation and not incarcerate him immediately. This case occurred coming up on 2 years ago. I believe it was early July of 2022. Without getting into any arguments that appear to address guilt or innocence, I don't want to mislead the court or send the wrong message to the court. So we're not arguing about that. But the initial 911 call that came in reported Mr. Luttrell engaging in some odd behavior, including crawling around on the grass, making comments about his daughter being kidnapped. And so certainly things that would lead a reasonable person to believe that he was suffering from some mental illness. Now, with that being said, he was also highly intoxicated, and we don't challenge that in any way, shape, or form. He admits to that. He understands that. He's been working on his sobriety since this occurred, so we're not arguing that he wasn't under the influence as well. But the request was really in the nature of getting him some help, more so than it was getting law enforcement involved because of any criminal activity that he engaged in at that time. It did result in a violent encounter with the police. We certainly understand that the court takes those things seriously, so we don't mean to minimize what occurred. There was some body cam footage of it as well. And when the body cam starts, you see...
The judge kicks things off by double-checking the paperwork like a teacher reviewing homework before class starts. Both attorneys quickly confirm everything is correct. Nobody's trying to add surprises today. Then the defense steps in to explain the defendant's background, hinting that this situation is more about someone needing help than punishment. It all began with a weird 911 call, alcohol, and mental health struggles that spiraled into a chaotic run-in with the police.
Mr. Luttrell ordering the officers off the property. Officers obviously said it doesn't work that way. When he refused to follow their lawful command, specifically to get on the ground, that's what resulted in the confrontation with the police. He was physically assaulted with them. He did obstruct. He did resist. He freely admits that. Judge, subsequent to that, he once he posted bond, he himself admitted him. Went to Point East initially. He walked into Point East in Alpena. Admitted himself psychiatrically, was ended up transferred to the psychiatric unit up at War Memorial Hospital in the Sioux. Stayed there for a period of time. He got back on his medication. The report indicates that he suffers from mental illness. He's been suffering from mental illness for a long time. Obviously, the result of not being on medication and also being under the influence, I think, caused him to behave in the way that he did. We did have him evaluated by the forensic center. They said he was criminally responsible. Once again, we're not challenging that finding. But I think in fairness to Mr. Luttrell, it's not as simple as him simply being drunk and wanting to engage in some physical confrontation with the police. I think he was suffering mentally at the time. He has been seeing a therapist at El Sable Valley Community Mental Health for a while. The court has a letter there. It sounds like from the therapist that the last psychotic episode he had was when this occurred. He's been on bond for a substantial period of time and has followed the court's bond conditions. He does have gainful employment as laid out in the letter. He is working a little bit more than full-time right now, a little over 40 hours, although he anticipates that as the summer goes by, those hours will increase. he's done his best to put his life back together.
The defense paints a picture of a man trying to fix his life. Right after getting out on bond, he checked himself into psychiatric treatment, restarted his meds, and actually stayed committed. His therapist confirms there haven't been any more incidents. He's working full-time, staying sober, and following every rule the court set. The defense's message is simple. Your Honor, he messed up, but he's genuinely trying to turn things around.
The other since this occurred, he physically looks better today to me than when I first had contact with him. So it appears to me that he's probably sober and probably staying on his medication as directed. He's just hoping that you would consider something other than incarcerating him for the period of time recommended. He's also asking that the court would fashion some sentence that might give him the opportunity to maintain his employment. That would be difficult, even if he had work release from here. I don't think that would be possible. The only possibility to maybe do that if the court does want some type of incarceration or something held over his head is if the court would consider some type of tether or house arrest. But he would not be able to, wouldn't be able to travel from here to his employment. It's too far away. And I'm not sure that the sheriff would allow that to occur anyways, even if there was work release available. By way of the fines and costs, Judge, he's expecting a check from his employer tomorrow. He can pay all of those tomorrow. He intends to do so. He did lay out in the report that he really doesn't have a real good memory of what actually happened here, but he certainly doesn't challenge what the officers say happened. Accepts responsibility for it. I'm not sure if he'll be able to communicate to you right now. He's pretty nervous and pretty scared about what might happen. So I just ask that the court consider those comments in addition to the letters that we provided the court.
Thank you. Mr. Luttrell, you don't have to tell me anything today. If you don't, I don't hold that against you. But you may make any statement to me you wish. Is there anything you want to say, sir?
I just appreciate any considerations and thank you for your time.
How willing are you to take care of this Indiana?
Now the defense makes a strong pitch for leniency. He argues that jail time would destroy the defendant's progress by costing him his job and stability. Instead, he offers alternatives like house arrest or ankle monitoring, hoping the judge picks something less damaging. He tells the court the defendant is anxious, but fully accepting responsibility, even ready to pay all fines right away. In short, Judge, don't break the progress he's finally making.